The very basis of entering into a contract starts with one party making an offer and the other party accepting the offer. According to the Indian Contract Act of 1872, Section 2, Clause A, it defines offer as being when one person will signify to another person his willingness to do or not to do something with a view to obtain the assent of such person to such an act or abstinence, he is said to make a proposal or an offer. So there are two parties in an offer. One is the promisor who makes the offer, and the other is the promisee to whom the offer is being made. And this entire offer should have some kind of legal implication for it to be a full-fledged contract. Okay, this offer must be communicated between two parties and it must be creating legal relations. So there are different kinds of offers, and they're very self-explanatory: an express offer, implied offer, general, specific, cross, counter. These are very self-explanatory in all in themselves. Express meaning they are expressly defined on what the offer is, like written, spoken, or anything else. Implied is something that is being defined by actions. General and specific depend on the parties, and cross and counter depend on how many people are entering into the offer. So now an acceptance. What is an acceptance? It is also defined in the Indian Contract Act of 1872 under Section 2 Clause B. It is defined as when the party to whom the proposal is being made signifies his assent thereto, the offer is said to be accepted. Thus the proposal, when accepted, becomes a promise. The offer can be revoked before it is accepted. So this says that once the offer made to the party, to the promisee from the promisor, is being accepted, then it is known as an acceptance, and then it becomes a promise. It becomes a full-fledged promise. But an offer can always be revoked before it is accepted. So if the offer is being accepted unconditionally, when the offer is being accepted unconditionally by the offeree, by the promisee, when the promisee is accepting it, he is like, yes, I like this offer, then it is amounting to an acceptance. Then the acceptance becomes a promise. This is what I've explained, okay? And then there are only three types of offers: express, implied, and conditional. Express is when the acceptance is in written form or oral form, it becomes expressed. So if somebody is offering to sell you a good and you respond in the affirmative, you're like, yes, I would like to buy this good, then it is an express acceptance. An implied acceptance is determined through conduct. And conditional acceptance is referred to as an eligible acceptance. So when the offer has been made and the offerer when the promisee says that they are willing to accept the offer, provided that there be some changes, it is called as being a conditional acceptance. There are some kinds of terms and conditions that need to be followed before it. So in acceptance की थोड़ी सी होती हैं conditions and rules. So the acceptance, it has to be communicated once done. It has to be communicated to the promisor, the person who made the offer in the first place. And mere silence, and this is one fact that you need to always keep in mind, mere silence does not amount to acceptance. And that in the end, on a concluding note, there is always a chance for revocation of an offer. It is offers and acceptances, they are the very standard law. They are the very standard contract law methods used to assess whether two-party arrangements can be done.